Mr. Bushnell, you were previously in court, entered pleas of guilty to the third-degree felony offense of evading arrest or detention with the use of a vehicle, and the second-degree felony offense of engaging in organized criminal activity. Those were for agreements of a 10-year probation deferred in each of those cases. I have received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Are there any additions or corrections to the report?
Just that it may indicate that he doesn't take full responsibility, but after speaking with him, he does take full responsibility for his actions and involvement in both cases.
I've also reviewed jail incident reports. Have you both been given a copy of those?
Yes, Your Honor. I have.
So you're 17 now?
Yes, ma'am.
I don't think he turns 18 until
December 26th.
And Your Honor, obviously due to his age, we want him to have the opportunity to get his life together, obviously not going into adulthood with felony convictions. I have preached to him the importance of following the rules and not.
And you can't do it, can you?
Okay.
You cannot. 21 incident reports since January 25th of this year. 21. Fighting, calling officers names, stealing food, instigating fights, being a bully to other people in the dorm. Ridiculous. So if you can't follow rules in the jail, what makes you think you're going to come in here and I'm going to say, sure, go be on probation out in our community? After y'all shot gun, I mean, this is serious. I'm tired of the shootings. I'm tired of people. You could have killed somebody. And because you accidentally didn't kill somebody, you get to get a probation. Not today. If I could send you to ISF, I would consider it. I can't. At this point, I'm going to reject the plea agreements. We will set the cases for a review in about 30 days. Let's see where we are, go over his options, y'all talk. If I can always do, upfront time, but we've got to get to a certain point where that would make sense. And so at this time, I'm just going to reset the cases. Again, I'm rejecting these plea agreements. And let me tell you, you get more of these, it's only going to get worse. I'm going to see them. A jury's probably going to see them a jury will see them if you go to trial. And you're going to end up in prison for up to 20 years because you can't follow the rules in our jail and you're acting like a little punk. So go stop acting like a punk, prove that you can behave, then we'll see what happens. When you come back next, I'll see how many of these I have. Go back with the bailiff. So it looks like the recommendation is substance abuse.
ISS, or substance abuse ISS.
Well, it actually says substance abuse cognitive, and we can't do both. So
Is there one more than the other, though? Understanding that the problems are both cognitive
Yes.
and drug. In your opinion, what do you think is best?
cognitive first with JCBI after.
okay, that would make sense.
And so that would be I understand this isn't an agreement, I don't think, but this is what we're asking the court to do based on the pleas that have been entered in the probation's report.
I guess you're on the record.
Mm-hmm.
In talking with Mr. Blunt, I think that he will do, obviously he's not going to refuse ISF, but he was going to suggest that he's using or has used marijuana or THC in the past to cope with anxiety issues in lieu of ISF to perhaps try to pursue something through MHMR.
Well, he didn't just use THC. He also used methamphetamine, and I'm pretty sure that's not very good for anxiety.
Well, he's not contesting ISF.
Yeah. So, Mr. Blunt, you're on probation for an extremely serious offense. I could be sending you to prison today for a very long time for violating your probation. Sounds like probation's willing to work with you. You've done some positive things while you're on probation, which are good, that you are going to treatment. You've made a great deal of progress. Those are the things that I'm really concerned about, but they're not the only things I'm concerned about. You've got to follow all of the rules, not just some of them. You've got to get this drug deal kicked. If you don't, you're going to go to prison over drugs instead of really what you are, the underlying offense is. Do you understand?
Yes, ma'am.
We're going to give you the opportunity. We're going to give you treatment. You take advantage of it and change that part of your life. Great. If you don't, you're back in here, and this is going to be zero tolerance. There's no messing up at this point.
Yes, ma'am.
Do you understand?
Yes, ma'am.
If the treatment that you're getting through JCDI is not enough, it's going to be up to you to be a grown-up and go to probation and say, I'm feeling tempted, I need more help. Nobody wants to go into custody for more help, but it's better to go in for 90 days than it is to go to prison for up to 20 years, right? Okay, so in clause number 15-21380, I'm going to find that you entered your pleas of true to counts 2 and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to follow the recommendation of the district attorney in probation and continue you on probation in order that you enter and successfully complete the cognitive track of the ISF program. And then when you're released, you will enter and successfully complete the JCDI program. These programs are doing two different things. The first one is to help you make better decisions. It's about thinking and making better decisions. The JCDI program is the drug intervention program to help you with what you need, hopefully, to stop using drugs. So you're going to have all the tools that you need. In all likelihood, you will be convicted and you will be going to prison for a very long time. Do you understand?
Yes, ma'am.
All right. Good luck to you, sir.
Thank you.
Thank you, Your Honor.
All right, this is cause number 21. Y'all can come up here. 21-36585. Sir, you Mark Phillips?
Yes.
And looks like Mr. Phillips is on probation for the third-degree felony offense of unlawful possession of a firearm by felon. And that was a 5-year adjudicated probation. Motion to revoke was filed, and we were here previously. It looks like Mr. Phillips pled true to counts. Let me get that pulled up to make sure. Pled true to counts 2 through 6, which was positive drug test, admitting to using marijuana, another positive drug test, an alcohol use, failure to attend AA/NA meetings. Entered a plea of not true to count 1, which was a new offense of assault family violence in Orange on October 3rd of 2025. Looks like that new case was refused over in Orange County. I'm assuming there's no witnesses with regard to count 1.
Not based on that.
And so I received an updated pre-sentence report. He entered those pleas. It was unagreed. Have you both had an opportunity to review the report?
Yes, Your Honor.
Judge, and I've also spoken to Ms. Shagwell about it.
I'm sorry, can you hear you?
I've also spoken with Ms. Shagwell about it as well.
And are there any additions or corrections to that report?
No, Your Honor.
Not from the state unless she has anything.
So I guess I'd like to know, looks like Mr. Phillips has been to ISF and through an intensive outpatient, but still having issues with regard to clearly substance abuse.
Yeah, I think the main, marijuana he uses is as a coping mechanism, which isn't good.
Well, it's going to get you put in prison, right? You just can't use it as a coping mechanism. You're being given all kinds of opportunities to get the help you need to find more productive ways to deal with stress. I understand there's been a lot of stress within your relationship with your child's mother. It sounds like you're kind of getting past that, which is a positive thing. even though it may be difficult, but, um, just based on the reading, it appears as though probation isn't completely opposed to safety and, giving Mr. Phillips an opportunity. Is that correct?
Yes, ma'am, correct.
Maybe not jumping up and down for it, but not completely opposed to it.
Yes.
Okay. Ms. Malfino? Thoughts
Judge,
on that?
I would defer to what the court deemed appropriate. I know in Mr. Smith's review of it, in the alternative, he thought 5 years in prison would be appropriate, and maybe it would just assist in saying that to the defendant, that if we're back, it will be more than.
Oh, no doubt. I mean, I would assume. I can't obviously say for sure.
Right.
I guess what we're set for primarily today with this time was because we were potentially going to have that new offense.
Right.
Okay, so we don't have that.
Right.
Mr. Phillips, if I give you this opportunity, number one, there aren't any other things to do. You will have had everything we have to offer at that point. If I send you to safety, we will have spent probably over $100,000 on you individually for this help. Do you understand?
Yes.
The opportunity? And I don't want you to go take this bed from someone else and not take advantage of it, because that's what you've done so far. So if you really want this opportunity, then it's time to take advantage of it. And you'll be on zero tolerance. There will be absolutely not a single mistake you can make on probation, or you will be back in here and you will be looking at, was it a 5/5 or what was it? No, it was a
I don't
10-year
believe
sentence.
so.
You've already agreed to a 10-year sentence.
You know.
So we don't even have to have a hearing. No one has to offer anything or say anything. I'm telling you now, you'll get your 10-year sentence. You've already agreed to that. This is a convicted probation. There's no thought process that any of us have to have if you violate again. You understand that? And I'm sure Miss Malfino will make a notation. If we're back here, she'll remind me of that. And I'll have this pre-sentence report that I've looked at, and it won't be good, right?
Yes.
All right, so what I'm going to do then is find that you entered your pleas of true to counts 2 through 6 freely and voluntarily. Find this counts true. Find sufficient evidence to revoke your probation, but I'm not going to do that. I am going to continue you on probation. I am going to extend your probation for 3 years and order that you enter and successfully complete the safety program. Whatever aftercare probation thinks is necessary, if it's the JCDI program or some other aftercare, you'll be required to do it so that you can continue to make good decisions and get this probation over with. Again, if you do that, then your case here in court's over. You'll get to serve that 10-year sentence while you're out on probation. If you don't, you will be again on the zero tolerance. And that means if you violate, you'll be back in here and you'll be looking at that 10-year sentence, right? And obviously, there wasn't an agreement. You do have some rights to appeal. I can't imagine that you want to do that, but I'm going to hand you this certification that shows, and I need y'all to sign that, and you can give him the bottom copy. Thank you for being here, and thanks for covering.
Yep.
Go.
I'll get these orders and I'll let you know.
Also, and I don't know, I know there was some issues when I read this with the self-medication with maybe some mental health issues. I don't know if there's enough for him to.
We didn't have any proper, like actual diagnosis. It was just more from conversations.
So I don't know if we want to do an evaluation just to make sure that special needs safety wouldn't be more appropriate. It may not be, but if y'all can just look into that.
Okay.
But one or the other. Thank you, ma'am. All right, thank
And I'll
y'all.
get that order. I'll get him to sign it and I'll get it.
Thank you, ma'am.
Thank you. Ryan,
Good morning. You're Khalil Bradley Harris.
Yes, ma'am.
And will your client waive the formal reading of the indictment?
And Judge, with the court's permission, we proceed on the lesser included offense of UCW. My understanding, and I included on the paperwork, that he will enter a plea of true at his parole hearing and be revoked on his parole. We're concurrent with this. Also, if I could just ask, just so that the record reflects to coincide with the previous times we've been in court, I did request Officer Champagne's video for Mr. Lane. It was up front for quite some time. I'll just like him to advise the court and the record that he did obtain that and review it for his client prior to this plea.
Okay, thank you. All right, Mr. Bradley Harris, the state has elected to proceed in cause number 25 DCCR 1334 with the lesser included offense of a Class A misdemeanor unlawful carrying a weapon. I'm just looking because y'all did state jail felony paperwork, but it's the lesser, so there's just a lot of stuff that doesn't apply on that state jail
Correct.
felony.
It needed
I
to
think-
be done with third degree paperwork.
Yeah, and then written in with the
Yes,
lesser.
ma'am.
I think that's cleaner. I'm gonna delete this. Y'all need to do the paperwork on the TDC paperwork since it's a TDC crime, and then write in the lesser on that one, please.
We have a bad meeting today.
All right, I'll call it as soon as y'all get that new paperwork done.
Why?
All right, we're back here. You're again Khalil Bradley Harris.
Yes, ma'am.
And this is 25 DCCR 1334. And I've already gone through with Mr. Harris his plea to the lesser included offense of a Class A misdemeanor unlawful carrying, correct?
Yes, sir.
And so, Mr. Harris, did you enter your plea of guilty to that lesser included offense freely and voluntarily?
Yes, ma'am.
And did you plead guilty to that offense because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lane?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And are you a U.S. citizen?
Yes, ma'am.
State tenders number 1.
No objection, ma'am.
It's admitted. Is there any evidence that Mr. Bradley Harris is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the lesser included offense of unlawful carrying a weapon. Sentence you in accordance with your agreement to a term of 180 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. It's my understanding that part of this is that you are agreeing to plead true in any parole hearing, and then whatever they decide to do is what will happen. Is that your understanding as well?
Yes, ma'am.
I am going to hand you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. All right, good luck to you, sir. You can go back with the bailiff.
This is the exact moment the courtroom energy
Cognitive, and we
completely
can't do
shifts.
both. So
Up until now, probation was still on the table, but once the judge starts listing 21 separate jail incidents, you can almost hear the patient's
Understanding
disappear.
that problems are both.
And
legally.
Jail behavior matters a lot.
Cognitive first would just.
Judges look at conduct behind
Okay,
bars as a
that would make
preview of how
sense.
someone
So that
might
would be
behave
our-
on probation
I
in
understand
the
this
real
isn't an
world.
agreement, I don't think, but this is
Wow.
what we're asking the court to do based on.
That
the
line
pleas that
right
have
there?
been entered in, probation.
Not today.
I guess you're wrong.
Short, cold,
Mm-hmm.
devastating.
In talking with Mr.
The
Blunt,
judge is
I think
basically
that
saying,
he
you were
will
inches
do-
away from a
obviously he's
second
not gonna
chance, and
refuse
you blew it.
ISF. He was going to
ISF, or
suggest that
intermediate sanction facility,
using,
is usually meant as
or
a
has
final
used
rehabilitation step
marijuana or
before prison.
THC in the past
But
to cope
here,
with
the judge is
anxiety
signaling
issues
something
in-
bigger.
in lieu of
Public safety is
ISF,
now outweighing
perhaps try to
sympathy.
pursue something through
Here
MHR.
comes one of the
well,
most
he didn't just
uncomfortable
use
courtroom
THC.
moments
He
in
also
the
used
hearing.
methamphetamine, and I'm
The
pretty
defense
sure
tries
that's not
framing
very
the
good
drug
for
use as
anxiety.
anxiety-related self-medication, but the
he's
prosecution
not
immediately pushes
contesting
back with
Yeah.
methamphetamine use. And that
So,
changes everything.
Mr. Blunt, you're
In
on
court,
probation for an
judges may show
extremely serious
compassion for
offense.
addiction,
I could
but
be
meth
sending you
cases
to
often
prison
trigger a
today
much
for a very
harsher
long
reaction
time
because of the
for
danger
violating
and
your
repeat offense
probation.
risk.
Sounds like probation's
might
willing to
honestly
work
be the
with you.
realest
You've
advice
done
given
some
in this
positive
entire
things while
courtroom.
you're on probation,
The judge isn't just threatening
which are
prison here.
good,
He's
that you
practically
are
begging the
going to
defendant to wake
treatment.
up
You've
before
made
it's
a
too
great
late.
deal of progress. Those
And
are the
viewers,
things that I'm
think
really
about this.
concerned
How
about,
many people
but they're
ignore
not the
small
only things I'm
consequences
concerned about.
until
You've
the
got to follow
consequences
all of the
become
rules,
permanent?
not just some of them.
And this is where
You've got to
courtroom
get this
deals become
drug
very
deal
real.
kicked. If you
By
don't,
accepting
you're
the
going to
plea
go
agreement,
to
the
prison
defendant is also
over
giving up the right
drugs
to
instead
challenge
of
the
really what
conviction
you
later in
or
most
the underlying
situations.
offense is. Do you understand?
That's why judges ask
We're
so
going to
many
give you the
repeated
opportunity.
questions.
We're
They
going
need
to give
make
you
absolutely
treatment.
sure the
You take
plea is
advantage of it
voluntary,
and change
informed,
that
and
part of your
legally solid
life.
before locking it in.
Great. If you don't,
Three
you're back in
different
here,
defendants.
and this is going to be zero
Three very
tolerance.
different
There's no
outcomes.
messing up at this point.
But every single
Do you
case
understand?
comes down to the same question.
If the
When
treatment
the
that
court
you're
gives
getting
someone
through
another chance,
JCDI
what
is not
happens if they
enough,
waste it?
it's going to be up to